Somebody in the comments recently brought up the issue of entrapment. But here's the interesting thing. In English law, entrapment is not a defence. However, it can amount to an abuse of process. So what do we mean by abuse of process? Well, there are two types. The first is it now impossible to have a fair trial? And the second is, even if a fair trial is possible, would proceeding attack the integrity of the criminal justice system? It's actually for the defendant to argue that it's an abuse of process, and they have to show that on the balance of probabilities. However, the CPS are told that if such an argument is likely to succeed, they should consider themselves whether to actually go ahead with this. So what do we mean when we say entrapment? Well, the test is it merely entrapment, or have the authorities acted as an agent provocateur? In other words, have they persuaded or somehow pressurised somebody who wouldn't have committed a crime into committing a crime? But that's to be distinguished by merely giving somebody who is prone to crime an opportunity to commit the crime. There are meant to be some safeguards. For example, they should only consider using entrapment where there's already evidence of criminality. So that could be going after a specific person, so you get test purchases for drug dealing if you think somebody's a drug dealer. But also it can just be generally. You get these sting operations where the police will set up shops and let the word get out that this is somebody who's willing to fence stolen goods, and then when people turn up with stolen goods, they just nick them. Or they've put cars in sort of areas where cars get nicked, and it's all videoed, and you get in the car and the doors automatically lock. That sort of thing. I mean, one way of phrasing it that we sometimes say is, did the authorities apply the trick to the defendant, or did the defendant apply the trick to themselves? That's the sort of general idea. I actually was involved in a case where this cropped up. It was one of those, remember the fake sheikh, Mazhar Mahmood, who himself ultimately ended up in prison. What he had done is, he had got my client, another chap, he'd come along, they had a scooter business, and they sort of buttered them up and arranged for this big deal where they'd have sold like loads of scooters out in the Middle East, and the contract was worth a lot. But then just as they were about to sign the contract after they'd done all the work, they said, oh, come on, let's celebrate, can you sort us out some drugs? And they were going, well, no, just sign here, please. But they said, all right, the contract's off then. So in the end, okay, let us make a phone call, because, they knew somebody. And they sorted somebody out and had a party to celebrate the contract. And then, at the weekend, they appeared in the news of the world. Now, what was interesting about that is the actual jury, because, they were directed that, this is not a defence. But the jury sent a letter, sent a note to the judge and said, but for the fact you've told us we have to convict this person, these people, we would have acquitted them. And, there's that thing, see my video on Bushel's case and jury nullification. We couldn't sort of say, you can acquit them actually if you want. And what was interesting about that is that the judge went, oh, okay then, I'll make the sentences suspended. I mean, we're looking at going away for anything between 3 to 5 years. So, that was quite a nice result there. But yeah, that's the thing. So, like, generally speaking, when you say, oh, this is just entrapment, it's like, so what? Also, even if the trial doesn't, get stayed, because the authorities are quite clear that the purpose of abuse of process is not to punish the authorities for bad behaviour, because, there is a public interest in prosecuting crime. So if any lesser remedy is available to make sure it can be a fair trial, then, the emphasis is on making the trial go ahead. So we have something called Section 78 of the Police and Criminal Evidence Act. And that's the general power to exclude evidence. There's a separate section, Section 76, that deals with interviews and confessions. But Section 78 is the general catch-all. And what the test there is, when considering all the circumstances of the case, is it right that this evidence should go in? So you could exclude the evidence that was gained through entrapment, but then carry on, with all the other evidence. And unlike America, we don't actually have that fruit of the poison tree doctrine that they do. I mean, that basically says that if there is any impropriety in the gathering of evidence, not only does that evidence go away, all the other evidence that you got from that sort of like lead, that goes away. So say for instance in America you torture a confession out of somebody, or you use what we call threats or inducements. So somebody confesses, and on the back of that confession then you go out and you actually find evidence. So oh, now you've told us that, we can go out and we've actually got physical evidence now. We've found the stolen goods or the body, or we've got your fingerprints now at a crime scene that we know where it all took place. In America, that wouldn't be allowed in, whereas over here it would be. So you'd have a trial where it was like, yes, we went to a lockup somewhere and found all these stolen goods, but you wouldn't be able to put in how they knew there were stolen goods there. So there you go. As always, hope you found that vaguely interesting. If you're finding that vaguely useful, that probably says more about, that's an interesting one. I mean, hopefully you'll never find this vaguely useful, but next time you're watching a television program and people are going, that's entrapment, you'll be able to say, yeah, well, so what?